Hello everyone, good morning. I'm delighted to have you here again. Sorry, yesterday I didn't make it. That was Monday morning, but I decided to record. This lecture and have it uploaded for you to review it or to go through it and raise any concerns in case you don't understand anything. However, I've just learned that you must have done coursework for other course units. So probably today, after this lecture, I'll as well send you my coursework so that can give you this week for you to prepare it and submit it next week. So I already sent you the notes for subsidiary legislation. For delegated legislation. Actually, sometimes they call it subsidiary legislation. So we can go ahead and define what delegated legislation is. Delegated legislation, as you can see from the screen, is defined as a body of laws created by other organs of the government other than the parliament. It can as well refer to the laws made by subordinate legislative bodies under the authority of a statutory power or parliament. As you're very much aware that it's the parliament with the law-making power. It's the parliament is the body mandated under the law to make laws. So we shall look at the Constitution of Uganda under chapter 79. Hopefully you guys can see my screen. 79. Chapter 79 states that functions of the Parliament. Subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. You see? So it's the Parliament that has power. Wherever there is a word shall, you see, the word shall, it's mandatory. So it's the Parliament that has power to make laws in Uganda. However, under section 79(2), it is stated that except as provided in the Constitution, no person or body other than the Parliament shall have power to make provisions having the force of law in Uganda except under the authority conferred by an act of Parliament. Under Article 79 2, we see that there is an avenue that another body can make power, can make laws, and that avenue is by Parliament giving it authority. Authority conferred by an act of Parliament. So the Parliament should confer that authority to make law to any other body or individual. So we've learned that it's Parliament that has the law-making power, as well as a possibility that Parliament can delegate or can authorize another body to make laws. That is under Article 79(2). Okay. Yes. Moving forward. Delegated legislation, also called subordinate or secondary legislation, may be made in a form of statutory instrument A statutory instrument can be defined as where an act confers on the president, a minister, or any other authority a power to make legislation exercisable by making proclamation, rules, regulation, bylaws, statutory orders, or statutory instruments. Any document by which the power is exercised shall be known as a statutory instrument, and the provisions of this decree shall apply thereto accordingly. So, every delegated legislation can either be called subordinate legislation or secondary legislation, and these are all termed as statutory instruments. So that's why you see SI wherever you see SI, it means statutory instrument. And whenever you see the word statutory instrument, they mean secondary legislations or subordinate legislation or delegated legislations. And those delegated legislations, we've learned that there are laws made by other bodies other than the parliament. So among those laws, among the delegated legislation or subordinate legislation may include um, may include rules, regulations, proclamations. Usually proclamations are made by the president, then statutory instrument, statutory orders, we've seen statutory instruments, and any other documents. We have bylaws, and many others. We shall see them later. Down here, we see, okay, it goes ahead to say that the above definition include ministerial circulars, as well as rules and regulations, also referred to as statutory instruments. So ministers sometimes are given powers to issue laws or to make laws. So they can be called ministerial circulars. It also includes bylaws and ordinances. Bylaws are usually made by local governments. Here they say local government for administration and proper management of affairs of the locality of certain localities, divisions, and districts, meaning binding people of within that scope. So I don't know whether you read those newspapers some time back where they said there is an actually local leader who was suggesting, actually the MP who was suggesting that laws should be made restricting the amount of bride price. You see, those areas of Acholi, Soroti, have a colleague from Soroti. They usually pay a huge sum of bride price. It can even go to 50 heads of cattle, or then goats, and then sheep, and many others. So the local authority think that this has hindered their daughters and sons having legal marriages. So since people, sometime back, it was so easy because cows were everywhere and resources were available. There was a big chunk of land. Someone would have like 1,000 or 900 cows in on his land. But nowadays things are scarce, resources are scarce. So the situation of then couldn't it's hard for us to apply the same to apply the same rules as long as those that were made some time back. So it has hindered their children, sons and daughters, from engaging in illegal marriages. So it has increased the marriage breakdowns and extramarital affairs and many others. So if the government comes out and maybe authorizes maybe a Choli region or local government to make laws restricting the bride price to be paid, we shall call that as a bylaw. We shall call that law to be called a bylaw. And remember, a bylaw is falls under delegated legislation or subordinate legislation, and it will be named like statutory instrument number, let's say number something something of, let's say if it is for 20, if it is made in 2022 or 2021, it will be named, it will be given a running number, and then it will be maybe a law restricting bride price in a Choli region. Statutory instrument number, let's say 25 of 2021. So, meaning delegated legislations are statutory instruments, as well as if it is made by a local government, it's a bylaw. However, if different bodies make different different laws. So it's only bylaws that are made by local government. Okay. Other bodies empowered to make bylaws: Uganda Communication Commission (UCC). Then we have Civil Aviation Authority, and then and other regulatory bodies. So we've learned that some other bodies, let's say UCC, it's a body corporate. However, it's a government and those bodies are called oh, I've forgotten, but they have perpetual existence, and okay, and they are independent of the government. Like you can sue UCC as a body. Instead of suing the government, you can sue UCC, you can sue Civil Aviation Authority, you can sue URA. Are we together? However much they are government bodies, you have a right, or you can sue them instead of suing the Attorney General. Yes. So members, we can go ahead. This one is important. You read through yourself. I don't want to dwell in too much into details that are unnecessary. Okay, so we should look at the methods of delegating power. The methods include general delegation and specific delegation. The general or simple delegation of power to make subordinate legislation comprises delegation to a donee of wide power. Donee is the body that is allowed to make laws. That we call we shall call them donee, because you see, when you have powers, the donor will be the parliament. The donee will be that body that is allowed, either the minister or the local government or an individual, and so on and so forth. So the donee in general legislation or simple legislation, the donee will be given a wide powers to make laws or act in his or her discretion within the limits which may have been set for him. So we learn that in general or simple delegation, the donee has wide powers or discretion to make the laws in depending on the can I say the scope, the limits that have been set for him. So it is different in specific delegation, where the donee is only restricted to take restricted in terms of powers in taking action only in respect of specific matters. So let's say we want to dealing with legislation of we shall say that if we are talking about uh, actually region, things to do with marriages, it means that Doni, the body that is allowed to make laws, will only make laws, or will have restricted powers in terms of making laws that rotates around marriages. Are we together? Marriage and no, restricted only in marriage, but on only bride price. Are we together? But if he's given wide powers in general legislation, they'll be given a wide coverage, like to legislate maybe the whole process of marriage. What is valid marriage and how should it be conducted, the kind of bride price to be paid, and when and how and why, and all that you get. But if it is specific delegation, we shall only be confined or restricted to only the bride price, not the whole marriage as a what? As a whole. Okay, so we've seen there are two methods of delegating power. We've seen general delegation, that is wide powers, and then specific delegation, restricted powers. Then we shall proceed to types of delegation. Uh, among the types of delegation, we have orders. Now we are seeing if the powers are delegated, what kind of or what types of laws are made. They include orders. Here we are told that orders are usually made by ministers. For example, the minister may make a law to dissolve a public body. We've seen orders including, remember the first lockdown when the minister, Betty Kamya, was the minister for planning and physical planning and what? Okay, and lands and physical planning, something of the sort. But generally was the minister of lands and physical planning. So Betty Kamya gave orders that there are no transactions that should be done during the lockdown, and they said if any transaction took place during lockdown, let's say change of title and maybe there is any exchange of maybe money for land and all that, or there is any changes made on the physical title in the Ministry of Lands, they will have been considered null and void. So those were orders and they were made by the minister. They are not anywhere in the Acts of Parliament. So the minister probably is granted power under the what? Under the Act. I'm not certain about the law and I'm not sure whether the law is there, but if the law grants or accords authority to the minister to give such orders, then they have powers to make orders. Yes. We also have regulations. These are made by ministers. Regulations are the means through which substantive and detailed law is made. For example, setting out how an act is to be implemented. So you will see we have the Civil Procedure Act. And that act is not detailed. It only lays the substantive law. So we have the civil procedure rules to help us know how to implement the act or how to implement the substantive law. And there are many other acts that have regulations that help to detail on how the main act has to be what? Has to be implemented. And here we are told that they are usually made by ministers. Then we have rules and set out, they also set out procedures and the way in which the parent office deals with the applications. And maybe made by ministers specific in or if specified in the Parent Act by a senior judge. So you will see that we also have rules. They are also made by sometimes ministers or specific office bearers, and these rules are usually they also help us to know the details or the procedures someone need to follow, maybe when applying for something. For example, we may have let's say um, the immigration, is it the Immigration and Citizenship Control Act or something? um, there is that act that deals with immigration and citizenship control act. So the minister made rules to describe on how to apply for a for a permit, for maybe a work permit. It also shows the procedures while you're applying for a passport, and many others. There are many rules actually. There are many rules, and we have regulations. There are many of them. As you will continue with your course, you will encounter many, very many of them. We also have schemes, IGI schemes made by the Charity Commission to amend how a charity is governed. So these are also bylaws. Then we have directions or directives. These are means by which ministers give legally binding institutions to a public body about the way in it exercises its function. So we've seen there are many directives. Actually, ministers give directives. I've seen the Chief Justice giving directives, many of them, and actually there is the recent one on how we should conduct the online court procedures. So we saw even the directive, the first one that was putting on hold court hearings during when COVID, before the lockdown actually. Then even during the lockdown, the Chief Justice issued others. There are quite many Chief Justice directives. We have bylaws. We said these are usually made by local governments. Okay. Requirements of a delegated for delegated legislation. So under the requirements, we shall see when someone is making a delegated legislation, or when an authority is given power to make a delegated legislation or a law. What is required of them? What those requirements that they have to meet? First of all, consultation. Since subsidiary legislations deal with matters which are technical or localized, these are best addressed through a process of consultation which experts or people are likely to be affected by a particular law. So we see that most of the time delegated legislation are usually done wherever Parliament thinks that this is a technical part of something or a project that needs to be handled by people who are knowledgeable in that aspect. For example, if Uganda is the Parliament is legislating or making a law on, let's say, oil, few people are acquainted with oil. Maybe they can talk about how finances will be dealt with and who should head what. But when it comes to the real oil, they may not know. You see, most of our MPs, some of them are senior. You see, to qualify to be an MP, you just have to be a senior 6 graduate. So most of those people are just lay people, the likes of Katorubama, your MPs from your villages and all that. So these MPs are not technical people. If something needs technical knowledge, they always do delegate the power to a certain ministry, let's say Ministry of Energy. That's where they will handle things to do with, they will have such a minister, um, uh, can I say, uh, collecting together those people are acquainted with oil, and they sit down and legislate on such what aspects. If it is something to do with the medicine, maybe they want to do a law regulating COVID-19, they will not come into parliament and start asking the opinions of every minister, every member of parliament. Why? These are people who are not health officials, so they will have to delegate power to the Ministry of Health, and such Ministry of Health will sit down and collect its best doctors and all that to legislate upon such. So we're saying consultation is the key in delegated legislation. Why? These matters are of technical knowledge, and we also have this aspect where that delegated legislation is done usually when a matter is localized, just like we talked about actually marriages, that if the matter is localized, not every MP can submit on the same. The way the situation is in Masaka is not the same way the situation is in Vundivujo. You get, the way people in Gulu behave is not the same way how people in Kamwenge behave. So you can a person from Kamwenge is likely not to submit on issues that affect what Gulu. So if the matters are localized, then we shall need to consult Gulu people if it's for Gulu. If it's for Kamwenge, still we shall consult people from Kamwenge if it is a law localized for Kamwenge. Okay, so consultation is the key. Then antecedent publication. Yes, you will see under bylaws, before any bylaw is made, someone will propose the law. When it is still a bill, it will be pinned on the notice board. Let's say the local government or the district headquarters offices. It will be pinned on the notice board for people to read and do what, and give their opinion. That is what we call antecedent publication. Okay, I'll go through it faster because I know you have read. Then subsequent publications. Then under section 16 of the Interpretation Act, it is a requirement to publish all subsidiary legislations in the Gazette, so as to become judiciously noticed. There is this case, you read it. So it is a requirement that wherever, remember these are quite many, there are thousands and thousands of subsidiary legislations. So if they are not advertised, actually they are usually put in the Gazette. Gazette is the government official printing or official newspaper. However, we still feel it's not enough, because how many people read the Gazette? How often do you hear that such and such was written in the Gazette? So I hope in future when we become MPs, or inshallah when I join the parliament, we shall also consider putting it in local newspapers, because I know people will always buy New Vision or Bukede or whatever than buying Gazette. So it's important that it is published. You read the case. There is also approval by legislature. Of course, delegated legislation has to be approved by the legislature. Like most of the time, after making this law, they give you power to make a law, and then after making a law, you have to take it back to parliament for the members of parliament to go through it and then approve it. However much they may not have the technical know-how to, maybe in a certain aspect, but at least they can tell that no, this is going extra mile. So it still reserves the power. Parliament still reserves powers to approve or to pass such a law. Yes, confirmation, it's almost the same. Parliament will need to first confirm. Delegation to make regulations may be subjected to the requirement for confirmation or approval, or by consultation with the minister or other persons. So usually it's the Parliament may reserve the right to confirm the law, or may give it to a minister or someone else. Subsequent publications, we've seen that after we looked at antecedent publication, then there is subsequent publication. It's the same. So this is the same what? The same page. Okay. Consent. Some laws require that subsidiary legislation be laid before Parliament before they become effective. So the purpose of this requirement is to obtain parliamentary consent. They also referred us to the case of Ara versus Wakiso Estate. So wherever the Parliament reserves the right to consent or to approve or to confirm, the law, that subsidiary legislation cannot become a law until it is consented to by the Parliament. Okay, for now I will stop here so that I don't make this audio so long, to make it not be able to be shareable. So we shall continue with justification for delegated legislation later. Yes, thank you.